Nonetheless, my duty is to decide on the proper sentence, knowing as I do that no life sentence passed on you can ever heal the bereaved family's loss and grief. In the small hours of Saturday the 18th of February 1999 in Felixstowe, Emily Doherty had been out clubbing but ended up separated from her friends and her husband. So she set off to walk back to where she was staying. You tried to kidnap her, but she was too alert and too quick and escaped, managing to rouse a couple by banging on their front door, who then called the police. I am sure that if you had managed to abduct her, you would have killed her. That is a dreadful thing to conclude, but I do so based on what you did the next night, what you did in 2006, and on the simple fact that Miss Doherty had seen your face and your car's number plate. So there is no way you would have set her free to have you arrested. That same Saturday, the 18th of September, Victoria Hall went to her part-time job, then came home and got dressed up, ready to go out. She left her home in Trimley St Mary, just by Felixstowe, about 9 p.m, and met with her friend Gemma Alger. The two of them went to the Bandbox nightclub in Felixstowe. They had a drink, they danced with each other, and at 1 a.m. they left. They went and got chips near the seafront and then set off to walk home, singing as they went. They parted company quite close to their homes at about 2:20, and that was the last time anybody, apart from you, saw Victoria Hall alive. Miss Hall's naked body was found 5 days later in the village of Creeting St Peter, about 25 miles from her home. Expert evidence shows she must have been killed within an hour or two of being abducted by being asphyxiated. The fact she was naked and the later discovery of your DNA material in swabs taken from her vagina and vulva show you not only abducted and murdered that child, you also either raped or sexually assaulted her. I've heard today evidence from her brother Stephen Hall on behalf of himself and his father Graham. I've also heard from Miss Hall's best friend Gemma Alger and from Emily Doherty. Miss Doherty has been left with lifelong anxieties about walking after dark and being spoken to by any man she doesn't know, and by a sense of guilt, blaming herself absolutely wrongly for not being more insistent that the police at the time took her case more seriously. Gemma Alger spoke of being traumatised and changed for life. Graham and Stephen Hall spoke in simple, calm words that are hard for any decent person to listen to. They spoke of the loss of Victoria's plans of university, marriage and children, the pain that has lasted for 26 years and is going nowhere. Graham Hall writes, and I quote, "I miss Victoria every day and will do so for the rest of my life." Perhaps the only thing that can be said in your favour is that you pleaded guilty. Your delaying until almost the day of trial, however, meant that Miss Hall's mother, Lorinda, died in December last year without knowing that her daughter's killer had finally been brought to justice. The nature of a life sentence means the other terms of imprisonment for attempting to kidnap Miss Doherty and kidnapping Miss Hall have to be concurrent. That means totality and double counting between the different counts are not issues. To reflect the attempted kidnap in the total sentence I pass today, I will add an element to the minimum term. Under the Sentencing Council guidelines for kidnapping, I need to assess your culpability and the harm caused, or, by way of Section 63 of the Sentencing Act 2020, that might foreseeably have been caused. Victoria Hall died and Emily Doherty would have done had you been able to carry out your plan. Both were young women, alone at night, and therefore you were deliberately targeting a particularly vulnerable victim. That places both offences in category 1A with a starting point sentence of 11 years and a range of 8 to 16 years. The death of one victim and the prospect of the death of the other would lead me, after a trial, to impose sentences of 14 years for Victoria Hall's kidnap and 10 for Emily Doherty's, the latter reduced as it was an attempt. Your late guilty pleas mean those sentences will be 12 and 9 years imprisonment. Guidance on the imposition of the mandatory life sentence minimum term is set out in Schedule 21 of the Sentencing Act 2020. I've considered the decision of the Court of Appeal in the case of Stewart, Cousins, Tustin and Hughes. I will not add to the length of these remarks by rehearsing what's set out with great clarity in that judgment, save to highlight 2 points. First, Schedule 21 must be applied in a flexible, not rigid way to achieve a just result. Second, whole life terms are a sentence of last resort for crimes of the greatest gravity, and if I am in any doubt about imposing such a sentence, a minimum term order is likely to be the correct disposal. These crimes were committed in 1999, which means I have to first consider what the minimum term should be under the modern day provisions of Schedule 21, then consider if I need to modify that term so as not to exceed that which the Secretary of State would have chosen under the law that was in place in 1999. How far your sentence for the murder of Victoria Hall should be increased because of the 5 later murders is not, legally speaking, straightforward. The Court of Appeal have made clear that those later murders do not, under Schedule 21, mean this crime counts as a, quote, murder by an offender previously convicted of murder, unquote, because you killed Victoria Hall some years before those other victims. See Stewart, Cousins, Tustin, Hughes and Monaghan. I am sure, however, that your situation must be made more serious by those killings, though I must be careful not to elevate this sentence to the extent I am punishing you again for offences that have already led to 5 life sentences. I would regard those crimes as relevant to the task I have to carry out today, and with respect I have my doubts as to whether a previous decision of the Court of Appeal is properly understood as excluding that conclusion, and as a part of Archbold in the case of Darrigan are the relevant references. The Court of Appeal decision of Ali Adam expresses far more authoritatively than anything I say the same doubt about that understanding of Darrigan, but confirms that later offending can be relevant to the sentencing decision. If, and I stress if, I was just applying Schedule 21, I would have passed a whole life term, given 1, that schedule defines a child as anyone under 18, and the murder of a child involving the abduction of the child would normally be a case for that sentence. That applies here, as Victoria Hall was 17. 2, there is very significant aggravation in the rape or sexual assault of Ms. Hall. 3, she must have experienced mental and physical suffering for some period of time before you killed her, between 1 and 2 hours. 4, there must have been a significant degree of premeditation given the attempt the night before. 5, your later conduct, however it is legally characterised, in committing 5 murders in 2006 aggravates your case. 6, there is a need to add to your effective sentence to reflect the attempt to kidnap Emily Doherty the day before. I do not add to it for the kidnap of Miss Hall, as I've already taken that as an aggravating feature of her murder. 7, there may be some slight qualification to treating Victoria Hall as a child, as she was only weeks away from being an adult, and there is definite mitigation in your guilty plea, but those matters are far outweighed by the aggravating factors I have just listed. Do I need to modify that term so as not to exceed that which the Secretary of State would have chosen under the law that was in place in 1999? In my view, I do. I read the Court of Appeal decisions to which I was directed by the prosecution and defence, in particular Sullivan, Gibbs, Eleanor and Eleanor. There are a number of aggravating matters under the guidance at the time, as set out in Lord Bingham's letter to judges, and they are the same as those I have already listed. I am very conscious, however, of the case of In re Taylor, in which Mr. Justice Openshaw, a distinguished judge, hugely experienced in the criminal law, commented that under the old system, quote, whole life terms were reserved for the very few notorious multiple offenders, end of quotation. I conclude that I cannot approach the sentence for the murder in 1999 on the basis I'm punishing a serial killer, as you were not yet that. And there is at least a steer against regarding you as such in Stewart and others, the case I've already referred to. All the aggravating factors I have already listed would have led, under the old rules, to a minimum term slightly above 40 years. But given your late guilty plea, I deduct 1/20th, so 40 years is the term I will impose. Even if this was your only life sentence, given your obvious dangerousness and your age, it is extraordinarily unlikely you would ever be released. Given the sentence already imposed for your other dreadful crimes, it is well nigh certain you will die in prison. The sentences I impose are: 1, for the attempted kidnap of Emily Doherty, 9 years imprisonment concurrent; 2, for the kidnap of Victoria Hall, 12 years imprisonment concurrent; 3, for the murder of Victoria Hall, I pass a sentence of life imprisonment with a minimum term of 40 years. You can go now.
No, it's the picture. That's the picture. Fair enough. If you don't know, you don't know. exactly. It's jargon based. And this is it. It's jargon. And so essentially it was like, I know what that is. And I unfortunately just don't know what but he's one of those pretty such an impossible looking guy. The face on like that. It's the way you handle the ball down that sort of like this level, 1, 2, 3, 4.
That was what stand dash, just me. Huh?
Just remember.